So one of the reasons that we asked to do this pop-up was because after the last pop-up, I went to Patty, who runs our diversion in the office, and told her these wonderful ideas that we had heard about. And she said, hey, it would be great if there was some way for us diversion coordinators who aren't lawyers, who don't get invited to these meetings, could talk and share ideas, because she has wonderful ideas about how to do things, but would like to know if other people had done them. So one thing that we thought of was creating a listserv so that people involved in diversion can share those ideas and send those emails and connect with people. So I've created that on IO group. I'm on one of those for the digital prosecutors. So if you just send this email, send any email to this address, you'll get involved with that. And I will put it in the chat as well. So if you just want to send an email, that way we can all communicate on diversion topics. These are the diversion classes that we have available now in our office. The ones in blue are our misdemeanor diversion, and the other ones are for felonies. We're mainly just going to talk about the felony diversion program and how we're doing that now. And I think for the most part, the principles of that program are the same throughout them, although Patty can correct me if I'm wrong. And so I want to give you, kind of like Nicole, I want to give you a little bit of a history of how we did diversion in Maricopa County. And we are absolutely enormous. Right now, we get about 50,000 felony submittals a year to deal with. And for the last, I've been with the office 23 years. For the last 22 years, until we recently changed, we had one felony diversion program, and it was called TASK, and it was solely for drug crimes. And it was a one size fits all. We had it both offered pre-file and post-file. So if someone was reviewing a submittal or a police report, they could send a letter to the person saying, hey, if you show up to this task and complete the program, we won't file charges on you. Or if the charges got filed, we could offer it post-filing once they have a lawyer. And so we had a lot of problems with TASK, and the biggest problem we had was it was a one-size-fits-all program. So it was nothing but drug cases, and you had to test, so you had to go drop urine every so often. You had to go to a meeting to learn about drug prevention, and I think you had to go to maybe 12-step programs meeting, or some number of meetings. And it didn't matter if your issues were homelessness or mental health. No matter what your issues were, you had to sit through a few meetings, and then you got the case dismissed. And we found that our group, because we didn't really have this program, they weren't communicating with us. They weren't telling us when people were failing in a timely fashion. So 12 months after someone didn't show up to task, we'd get a letter saying, hey, this person never showed up. And now we're 18 months to 2 years after the crime was committed, where we have to figure out what to do with this person. The pre-file program part of it was terrible. So the people who showed up when they got this letter did a great job. They were really motivated. They saw a letter from the saying, we're going to charge you, and they got scared. They showed up, they completed the program. But that was just a tiny percentage of the people that we sent the letters to. So when they showed up, it was great, but most of them didn't show up. And because we never got any feedback from TASK, now we're looking at charging them 18 months after they committed the crime. So those were the issues that we were faced with when we were building our new program. And Patty's going to talk about how our program is set up. But the lessons that I've learned as the attorney supervisor are kind of similar to what Nicole was just talking about. It was getting buy-in from the prosecutors. And, as she said, prosecutors like to prosecute people and put people in jail. And for me, it's more of consequences. They want to feel like this person has a consequence for violating the law. And so we really have to focus the messaging within our office as this is not them just getting off scot-free. And, I get where they're coming from, because 20 years ago, I would have said, throw these people in jail. That's what they get for violating the law. And now when I talk to our new attorneys, I tell them our number one goal when we're prosecuting these people, especially for these low-level felonies, is that we never see them again. If we can get this person a job and become a productive member of society, then we have done our job. We have made society safer. And that's really how we have to look at that. And it's really the older prosecutors, how do we choose our supervisors in our office? We choose the best trial attorneys and the ones who get the best results and send people to prison for a long time. And those are the people who are resistant to diversion. So you really have to get them on board when you're doing this. And we have really tried to do a better job of getting the defense involved in our program. And so Patty and I taught our prosecutors, taught a class on diversion. And the questions were all focused on what are the consequences for what you're doing? And then we went and met with the defense bar, and they told us everything we were doing wrong with diversion. And of course, being a 23-year prosecutor, I just kind of cringe whenever the defense tell me I'm doing something wrong. But when you got down past the way they were communicating, telling us that we're violating the Constitution, and listening to the problems that their clients had going to the diversion program, that they didn't, things that we would never think of, that they didn't have computers, they didn't have phones, that if the working poor couldn't show up between 8 and 5 because that's when their job was, and they had to take 3 buses to get to the intake appointment, so they had to be open until 8 o'clock at night. Starting to listen to them and go back to them regularly and say, what issues are your people having? Because even though our goals, as Nicole said, are different than the defense, really, once we put someone in diversion, we want them to be successful, and the defense wants them to be successful. And so, kind of communicating, and Patty's done a great job. When we have someone successfully complete diversion, we try to follow up with our lawyers and our supervisors who put them there so that they can see, listen, this person did it. You took a chance on them. They completed it. Good job, to give that positive loop, because as prosecutors, all we ever see is our failures. All we ever see is the person coming back into the system, and we get another police report on them. And if they do well, then we shouldn't ever hear from them again. So we need to do a better job communicating. Patty?
Okay. Hi, everyone. I'm Patricia Cordova. I just want to get into the nuts and bolts, as Jason said, about how we set up diversion in our office. So when I came on board, I was told, put together diversion. There was really no roadmap, exactly what Nicole was talking about as well. And I will say that we had diversion programs, TASK being one of them, the one that Jason talked about. And then we had a few others. They were scattered throughout the office. There were contractors involved administering the program. And I will tell you, no one was really watching it. So one of the first things, and something we learned very hard in Maricopa County, is our program, the TASK program, the 30-year MOU. It wasn't even a contract, but the organization was called TASK, and we had a 30-year relationship with them. That was not monitored in any way. And honestly, it blew up in our face, to say the least, and it became a federal lawsuit. So I'm emphasizing this to tell you, when I talk about these fundamentals, my very first lesson learned is talking about, if you're going to be working with the behavioral health organizations that are in your community to set up these programs, have robust contracts. That's so, so important. You cannot allow an organization to go off and do their own thing, or what we call scope creep, because they will. If it's not monitored, then the organization will do what's in their best interest. So the first thing we did is we really, our setup, our model in our office is not to have diversion officers. I have an administrative unit, and they do the paperwork processing with attorneys in the court and with the providers. And then I have another small group of us, and we work on contracts. We work on metrics. I actually have a criminal researcher, a PhD criminal researcher. So we set up metrics. So we are the administrative end, and then we give out contracts for our diversion programs to behavioral health organizations. So we monitor those once they're established and they are robust. We monitor them. We actually have protocols, and we hold them to all the standard terms and conditions. There are many terms I could talk about, but one that's been brought up, and I'll emphasize this as well. Yes.
Sorry, 5 minutes left.
Okay, you have to consider a person's ability to pay. So we're closely working with our Medicaid system. We make sure that all the programs we prescribe in these contracts are evidence-based, or they do have principles. One that was brought up by Nicole, R&R, risk needs responsivity. That is a way of how to work effectively with criminal offenders. We also use a validated assessment. And so all of our providers are trained on how to use this ORAS assessment, and we get the risk to reoffend and their criminogenic needs. If you're not familiar with that term, those are all the factors that research tells us are correlated to criminal behavior. So this contractor, through their programming, has to address their level of risk to offend and their criminogenic need. We also collect monthly stats, and we are constantly doing program evaluations, and we work in partnership so that we can improve together with our behavioral health organizations. The next slide, Jason. I'm going to go through this quickly. I am focusing on the felony diversion program. So just to have a practical sense of this, so a defendant is referred to the provider. They're enrolled in diversion. It's the felony diversion program. The felony diversion has 6 tracks. Before they're assigned to a track of treatment, they go through the ORAS assessment. And again, we are saying what level of risk to reoffend. So is it going to be low to very high? And what are their criminogenic needs? There's 8 criminogenic needs that research tells us to watch, but one that is just huge within the criminal justice population, and one that stands out is substance use disorder and any use of illegal substances. So tracks 1 through 4 center on substance abuse needs. So if they have a score, this is getting a little technical, in the criminogenic factors, it goes from 0 to 6, but if they're in the 3 to 6, and then we divide them into low up to very high risk. You never want to put together your low risk offenders with your high risk offenders, because there's a difference in the duration and frequency for a low risk offender to the high risk. So it will never be the same, and you do not want to overtreat or undertreat the offenders. So we divide these out into tracks. So track 1 is low risk. Track 2 is also low risk. There's a difference there. They have the criminogenic need for substance abuse. You will see that the track 1 for the low risk, there's only 10 sessions. Track 2 is 10 sessions, but it's different because track 2 is for relapse prevention. So there's a little bit of difference in that defendant. And you'll also see we have curriculum that's prescribed, evidence-based curriculum that's in green. I'm not sure if you can see that, but every track has that. Next slide. So track 3 and 4, again, it's focusing on substance abuse as a criminogenic need. They've got that score through 3 through 6, but now you're into moderate level. So then we're going to up their duration and frequency of treatment. So you can see that's 2 times per week, a total of 20 to 34 sessions. They have a curriculum as well. That is standard outpatient counseling. If you're in track 4, you are high risk to reoffend, and you're going into intensive outpatient treatment for substance abuse. Again, another evidence-based curriculum is there, and this is really a step-down program. So there's phase 1 through 3, and we start very high at 3-hour groups 3 times a week, and then it goes down to once a week and 1 time per week for a counseling group. So if you're in tracks 1 through 4, you're going through random drug testing as well. So we focus heavily on substance abuse. And then next slide, Jason. So tracks 4 and 5 in the felony diversion program, they are not focused on substance abuse as the criminogenic need. It's one of those other 7 out of the criminogenic needs that there are. And so we really have cognitive behavioral interventions. But again, we divide this by low risk. We put 1 group there, and then we have the moderate to the high, very high group goes into a track 6. And again, you can see the difference in duration, 12 sessions in track 5. If you go into track 6, you're up to 25 sessions. So we just started this program in May, And we
So
are
Patty,
monitoring.
we're at the 1 minute mark, but if you're close to wrapping up, we want to see the end of the presentation.
So I can just leave it there. That gives you a little bit of sense of where we are at with the felony diversion program.
And I do want to add one thing. We are doing this during the pandemic. So we have transitioned to a lot of these classes being virtual. So we're able to put people in and process them while COVID's going on.
And this is not a drug court. This is your program.
Correct.
Correct.